Hi, my name's Garrett Dailey, and I'm a family law attorney from Oakland, California. I'm a family law specialist, and I've been practicing family law for, pushing 40 years. And as a young lawyer, one of my big concerns, and I'm sure a lot of you share the same, is how to get clients. And there are lots of seminars and tips and courses being given on how to go out and solicit clients and bring them into your office, advertising versus social media versus bar association, etc. I'm going to take a slightly different tact for this segment. And the reason I say that is because over my career, what I've found is that there are certain clients or categories of clients that really you should avoid, or at least I've found in my practice that when I've taken people within these categories, I have always regretted it. Now, the list I'm going to give you, is it set in stone? Well, yeah, pretty much. At least in my practice it is. But you'll make these mistakes yourself, but you should begin developing a list of the type of clients that you really do not want. And after I give you my list, we'll talk for just a minute about why it is. So the first thing I think you should remember is never take a client simply because they can pay your initial retainer. Yes, you may, that $1,000 or $2,000 or $5,000 or even higher retainer may look really, really good when it comes in the office, especially at the end of the month. But in some cases, what I found is that initial retainer is the only money I will ever see in the case. And if I end up putting in $10,000, $20,000 of time on a case for which I've only received a $5,000 retainer, it was not a good investment. When a client comes in to meet you for the first time, one of the things that's really important, I find, is to get my staff's input. And normally they will have had contact with my legal assistant or a secretary or someone else in the office before they talk to me. And I'll always try to get my staff's input before I meet with them, because they get a different perspective of the client than you will. And every time I have taken a client over the objection, or let's say contrary to the advice of my staff, I have always regretted it. So listen to your that inner voice when you're talking to the client, when your staff has given you input. Listen to it. If you take a case where something inside you tells you it's a mistake, you will virtually almost always regret it. At least I have. So let's talk about some warning signs. Anybody who's come in and they want you to be the fourth, fifth, sixth attorney, there's a problem there. I usually will cut it off at 2 or 3, and then I look to see who the previous attorneys are. And if they're good, respected attorneys, there's a problem, and it's probably the client. If the client comes in, meets with you, and has nothing but bad things to say about their former attorneys, well, what are they going to say to the next attorney about you? Because that's probably what's going to happen. Any case where the ultimate fee award is dependent upon, I hate to say the whim of a superior court judge, but dependent upon a fee order. In other words, your client does not have the ability to pay you any fees. You're going to take the case, litigate it, based upon the expectation / hope that there will be a fee award at the end from a superior court judge. Remember, you're no longer working for an hourly rate. You are now working for a contingent hourly rate. So be careful. I'm not saying don't take those cases. I'm saying those are ones certainly to be wary of. Along that same line is if the case is complex but there's no obvious source to pay the bill. In other words, they've got a complex custody case or highly litigated custody case, but neither party has a great deal of income and there are no assets. Where's the money going to come from to pay the fees, to pay the experts, etc.? Be careful of that. Whenever somebody comes in and tells me that they want a fighter, I want a fighter. Well, okay, that's fine, but that means it's going to be a very litigious case. It means it's going to be expensive. There had better be a source of fees there. Right along that same line is, it's the principle of the thing. That's what I'm in this for, the principle of the thing. Well, that's fine, except at the end of the case, when you hand them a piece of paper, it says that you won or lost, and a healthy bill along with that. All of a sudden you're going to say, but wait a minute, that's it? So that's something I find seldom turns out well. I litigate over property, money, children, that sort of thing. Principle of it, that I leave to the constitutional lawyers. I'll pay your bill. Excuse me, of course you'll pay my bill. Why would you even say that? Somebody who sits there and tells me, don't worry, I'll pay your bill. What I find is that clients who are going to pay my bill don't need to tell me that. The only people who tell me, I'll pay your bill, are the ones who have no intention of paying my bill. I sound cynical, I know that, but again, I've made this mistake so many times that, well, not so many times. I've made it a number of times. I try not to make it anymore. If the case is more than you can handle. Now, I've been doing this a long time, but I remember one time I was called in, and it was literally $1 billion divorce. And I told the client, I said, I have the skill to handle this, but I don't have the resources. I don't have the staff, and I don't want to ramp up. I turned down the case. It was a great case, but I didn't have the resources to handle it. So think about that. Don't take on more than you can chew, even if it is a good client. When I say that, now maybe you have the ability to get help, whatever, that's fine. If the previous attorney hasn't been paid by this client, guess what? You probably won't be either. If this client has sued the previous attorney, that's also a bad sign. Now, maybe the attorney deserved it, but remember, that means you have a litigious client. If the client's going to be obviously difficult to deal with, then you might want to think about whether this is someone you want to represent, especially on a long-term basis. If it is a Marvin case or a palimony case for the plaintiff, I have litigated these cases. They are exceptionally difficult to win, and there's no guaranteed fee award at the end. Be very careful. Contingent fee cases, if somebody wants you to take a case on a contingent fee, we're family law attorneys. We're not PI lawyers. You shouldn't take that case. If somebody demands you do it for a fixed fee, don't do it. Even if you figure it's going to cost $5 and you charge them $20, don't do it. The reason is, the moment you get that check, from that moment on, you are working for free, and they can demand as much from you as they want. Don't do it. If the client demands a ceiling, there you go, that's the same thing. If the client balks when you tell them what your retainer is, your hourly rate is, don't talk them into it. That's a sign that this is going to be a problem. If they tell you that some other attorney will do it for less or charges a lower hourly rate, well, I just simply, I mean, what I'm thinking is, well, you get what you pay for. But that's okay. Then let the other attorney handle it. If they'd wanted the other attorney to handle it, they wouldn't be talking to you. And the one thing that really will do it for me is if they have been rude or otherwise acted improperly with my staff. It's much, much easier to get another attorney than it is to get a good legal assistant or a secretary. If you take these type of cases, they will have multiple ongoing adverse consequences for you. You're going to devote your time, your resources, and your money in the sense of advanced costs and other out-of-pocket expenses for this client, and you're probably not going to get reimbursed for it. Next, you're going to devote time that you could have been spending on other cases where you would get paid. So you're going to be wasting your time on a case for which you're not going to be paid, and not working on cases where you could be paid. And to me, I think the most important thing is this: it increases your stress and increases the likelihood of burnout. So there's really no good reason to take these types of clients. There are other attorneys who will be willing to do it. My strong advice to you is don't. I hope you enjoy your practice, and I hope you've enjoyed this little snippet.